You've seen her. You've seen her. Okay. Okay. Thank you. Bye-bye.
Attorney's in the building, Mr. Brown. We know that.
Excellent. Yeah, but that sign is pretty big, and the courtroom is dark, so that's a pretty big
We sent her
sign.
an email yesterday, saying
Oh.
we're going to get it moved down here today for other reasons.
So I'm going to check on just be there.
Here she comes. She's here.
Your Honor, please forgive me, I had calendared at 9, I'm very sorry.
Okay, you're
Sorry.
No
forgiven.
problem.
Sorry about that.
Okay, we are on the record in State of Arizona versus Mark Brown, which is CM 19-007-524. Counsel, not your questions, please.
Catherine Harriet for the state.
And Mary Ann Viana for the defense. Defendant Mark Brown is here out of custody, sitting at the table.
And Mr. Franklin's out ill today, is that correct?
Yes, Your Honor, I'm covering for Kevin Franklin.
All right, we were last here at the end of September, and the parties had agreed to add some time to try to secure some video footage, surveillance footage, I think from Walgreens and/or Sausage Deli. After we were in court, the parties were communicating with the court and each other, and both had agreed they wanted to try to secure a copy of this video for the court to review. And the court was advised that the video no longer exists, and so the parties are not submitting additional evidence. Is that correct?
That's correct, Your Honor.
Yes, Your Honor.
Is there any reason we cannot proceed to verdict at this time?
No.
No, Your Honor.
Given the delay, I've had a lot more time to think about this case than I do most of my cases, so I appreciate the time. But the verdict of the court's mind is quite clear. Court, Mr. Brown, excuse me, this is not moving forward, so I need to get, you like the film, and this doesn't move very well, so. All right, on the two counts involving the minor child, there's a disorderly conduct charge and a contributing to the delinquency or dependency of a minor charge. Finding Mr. Brown not guilty of those offenses, the court finds insufficient evidence to believe that there was any crime committed against the child. The child was in no way targeted. As far as the court could tell, the child did get upset because the parent chose to take her away from lunch. And every time a child gets upset, it's not a crime, and I don't see that the effect on the child from the conduct described amounted to any criminal offense. So I'm finding Mr. Brown, finding you not guilty of the two crimes against the child. Mr. Brown, of course, finding you guilty of the disorderly conduct against the victim, Ms. Fisher, and I typically will explain my verdict if that's okay with you. It's okay with you?
Yes, we would like
All
a
right, very good.
finding.
All right, so there is, giving it this plenty of thought, there are two questions. What did you do that day, Mr. Brown? What was your behavior? That's in dispute. Right? What you say happened and what the witnesses say happened is in dispute. Inconsistent. And number two, once I decide what it is you did, was there a crime committed? Obviously, the court's conclusion is yes to that second question. So, I do believe that, Mr. Brown, that you did go outside, followed Ms. Fisher and her child to her car, and that you were filming her up close, filming her vehicle, filming her license plate, and interacting with her even though she had repeatedly asked you to stop. Why do I believe that's the case? Well, a lot of the helpful information came from you yourself, Mr. Brown, in your footage. We started with the footage of Mr. Brown. You were in the sausage deli. You were immediately filming Ms. Fisher. You can see her in the film looking at you and ask you to stop. She had an upset look on her face. That's the court's interpretation. You made a comment, something to the effect that she's not going to like this. She's going to be on my website, and then you laugh. That puts the court into understanding what your state of mind and what your intention was at that time. You said that you testified that you never saw her after she went to the bathroom. You never followed her to her car, that you never filmed her at her car, and you never saw her outside. The court finds that not to be credible, and here's why. When you did film again, you were filming the officer outside. He had asked you to not film his family, and you said something to the effect, and these are not direct quotes, then get another job, which is really your justification for what you had just done. You said you didn't know her car, but really telling was the fact that on your footage on the second video, it very clearly shows you zooming in on her car. Once very clearly. Amy, can I help you? Something funny?
I'm fine, thank you, sir.
Oh, the gentleman in the back is laughing at the court, I'm guessing.
I can't hear you.
If you're in the courtroom, that's fine, but please act respectfully to all the participants. Appreciate it. All right, I'm sorry for the interruption, Mr. Brown. You deserve the attention of the court. The fact that your own recording very clearly zooms in that vehicle, you said it was just that was not coincidental in my mind. So clear, so specific that if you had never seen her outside, never been in her vehicle, you would never know that that was the vehicle that she was driving. So if the court finds your testimony not credible, that you did not have that interaction with her outside. The court believes that your intention in this whole act, in this whole circumstance here, Mr. Brown, probably not to antagonize her, but to provoke and antagonize the officer, that you had some personal issue. And that was really clear when the footage that you submitted shows you really personal insults at him, and really for the purpose that it appears that the court, I can't find another license plate. There'll be no person, purpose of doing somebody's license plate with that. You're trying to send a message that in the future you may be able to contact this person again. So, the court does find that you did commit the acts that were alleged, despite your denial, which the court did not find you credible. The court also finds that under the circumstances, in totality, this did amount to disorderly conduct beyond your reasonable doubt. So, Mr. Brown, for those reasons, the court's finding you guilty on one count, not guilty of the other two counts. Counsel, is there any reason we cannot proceed to sentencing? Any reason we can't proceed to sentencing?
No, Your Honor.
No, Your Honor.
Ms. Harriet, does the state have a recommended sentence?
Yes, Your Honor. Your Honor, the state is recommending a term of 12 months of court supervised probation. The state is also recommending Your Honor, unsupervised probation. The state is also recommending a fine of $2,500 with $2,000 of that suspended. The state is also recommending a term of.
Hold on one second. Mr. Brown, I don't hold this against you, but there's people back who are laughing at what's happening in court. I don't agree, it's disrespectful. I've asked you not to do that when someone's speaking, it's disrespectful. And I'm happy to have you removed from the courtroom if you can't behave yourself. This is not going to take care of this longer, so please control yourself and be respectful to the participants. I appreciate it. Go ahead, Ms. Harriet, sorry for the interruption.
Your Honor, the state is also recommending a term of suspended jail time. The state is requesting the full 180 days with credit for any time that Mr. Brown has already served in custody. The state is also requesting any minimum jail recovery fee, and then no contact with the listed victims, Ms. Brianna Fisher, and the minor victim, Kendall Soka, and then no return to their residence, work, or school.
Ms. Fisher is not here today, correct?
No, Your Honor.
Ms. Deanna, do you wish to change the court?
Yes, Your Honor. We ask that, in light of the facts of this case, Mr. Brown be given a no fine or any fine that is imposed completely waived. I think the facts do not rise to court supervision on probation, so any probation given, I think unsupervised, this case warrants an unsupervised probation period. And I believe on this case, did you spend any time in jail?
Yes.
Did they came and arrested you? You were
I was
booked,
arrested here
but for this charge.
for this charge. I was
So-
arrested
Yeah,
here.
there is a book
Okay.
book in the form of the court file.
Okay, so I think he was booked, so we asked the court to give credit, any suspended jail time, of course, be suspended. We're not asking for the whole 180 days. I think the facts warrant maybe a 30-day sentence, 1 day credit with the rest suspended. We also ask that the jail fees be waived. Again, this is all a very light sentence that we're requesting, but I think in light of the facts of this case, I think it warrants it. I think that's it.
And I want to make sure that the court is correct on this. It looks like Mr. Brown was booked into the jail and seen and released that same day, so he was in
Yes.
jail that day, correct?
It was after midnight. I was there for over 13 hours.
Right, but it's part of the same calendar day.
Yeah.
Yeah, part of the same calendar day.
I was released after midnight.
The credit for jail goes by the calendar day, so I'm trying to sort out how many days credit to give you to get credit. You're getting credit for that day. Okay, anything else, Ms. Ryan?
No, not at this point, Your Honor.
How about you, Mr. Brown? Is there anything else to say, sir?
You could address the court.
You're welcome to speak freely if you choose. That's your choice.
Probably don't say too much 'cause I think we're
Yes, well, just the 3 or the 6 to 8 questions that you asked Ms. Vianna in that, and she said no to every one. Was he loud inside the restaurant? Was he loud outside? There's no disorderly conduct. So I didn't do anything disorderly. I never talked to Miss Viana. I never said anything, and I never followed him out to the car. If that video evidence would have came through, it would have proved that. There's no way that I followed him out. The time doesn't allow it. So that didn't happen. So everything that you're saying that I did and that I'm being sentenced for, I didn't do. So that's very unfair because it's legal. Even if I did walk around the vehicle out there, it's not a crime to walk around someone's vehicle, and it ain't disorderly conduct. But I did not do that. That never happened. I went out once. 100% of the time outside was on film. 100% until when I turned it off, the cop left and everyone left. And when I went over to that entrance, filmed over there, I didn't know that was her car. I was just filming over the entrance. I never saw her car. So all that stuff that you said is not true. So everything that you said that alarmed you is not true. Even the time limit proves that. By the time I talked with the Air Force guys, then I looked over and saw the car and walked right out. Everything was on film. I turned it on as soon as I went outside and made that corner. So there wasn't no other time that I contacted the Mrs. Brianna. I never ever talked to her. So none of that happened. It just didn't happen. You know, everything that happened on the inside, you know, and Miss Viana admitted it was only a minute.
And I think you mean Miss Fisher.
I mean, Miss Fisher, I'm sorry. Miss Fisher, everything that happened on the inside, 38 seconds I had, and then she admitted she was only there a minute, so another 20 seconds, and nothing happened during that 20 seconds. She got up and went to the bathroom. I never saw her again. I walked over to the Air Force guys and started talking to them. No one was alarmed because nothing happened. So this is a charge or something I absolutely did not do. It just didn't happen. There's no disorderly conduct, and I just want to leave it at that.
Thank you, Mr. Brown. Before we continue on the issue of the substantive sentence, Ms. Fana, you had asked that the jail fee be waived. And Mr. Brown, the court appointed counsel for you, and there is a process for you to go through a financial screening process to get fees reduced substantially, attorney's fees and even jail fees. And when you go through that process, there is usually an envelope in the court file that tells you you've done that, and I can decide whether to make those reductions. And I don't see that in the court file. Did you go through the financial screening to get your fees reduced?
Up on the 4th floor and filling out a financial form?
104 actually, it's 104.
Oh, 104.
Yeah,
Have you done that yet?
I don't think I did.
Because I allow 10 days after today to get that taken care of, so you can apply to get your fees reduced, should you choose that option. So that wasn't done yet, but you still have 10 days.
Yeah, I didn't know anything about that.
Okay. Well,
I'll walk them through the process, Your Honor.
That's why the court policy now is that we're giving you 10 days to get it squared away, just in case you forgot or didn't know. Mr. Brown, the court is going to realize you disagree. There's a disagreement as to what happened. You left it to the court to decide the facts, and the court did make facts based upon the entirety of the evidence. I appreciate and respect that you disagree with the court's ruling. You're placed on 12 months of unsupervised probation. The court thinks that's appropriate to make sure that you stay out of trouble for the next 12 months, and most principally, that you have no contact with Brianna Fisher or Kendall Suka, if I maybe pronounced that incorrectly or correctly. The court is going to suspend the fine of $750. Court sees no reason to make you pay a fine in this case, given the circumstances. The jail term is 10 days. I'll give you credit for your 1 day. The court will suspend the remaining 9 days if you complete probation successfully. So you have the power to avoid that additional 9 days in jail by complying with the court sentence in terms of probation. So you're at the jail booking for fee of $349, which I said you can petition the court to have reduced if you are financially able to pay. The attorney's fees again are assessed at $450. That's just where they start. You have 10 days to apply to have those reduced. You can take care of that today while you're in the court if you wish to go to 1.04. The court's going to order sure that you complete 100 hours of community service. I'm going to give you until April 15th. We'll make sure to get that done and get proof back here to the court. Actually, I typed in May 15th, but I said April. That's my error. May 15th, 2020, which should be plenty of time to get the hours. We'll give you an instruction sheet that tells you how to go about getting those appropriate for this year. For the jail fees and attorney's fees, or whatever those final assessments may be, sir, do you intend on paying those in full today, or do you need time to pay?
Anytime.
Would you like to arrange a deadline to pay the whole amount or a monthly payment?
I want to talk to my attorney. What is the whole amount going to be?
Well, that's going to depend. If you do nothing after today in terms of applying for a reduction, the total is $349 plus $450 plus a $20 time payment fee. So that's roughly $820 minus the dollar.
And so if he takes the payment plan, anything that, if he gets it reduced, it just reflects that, whether it's a payment plan or a pay in full date?
Correct.
Okay.
So for instance, you can apply to have the attorney's fees reduced to as low. The lowest is $50. You apply for that. If you qualify for that reduction, then your payment plan is still the same. The monthly payment plan is the same, but the total amount you owe is going to be reduced. So there's going to be some assessment for the jail and for the attorney. It's just a matter of the amount.
Okay. Well, I would recommend just doing a payment plan.
All right. So we're going to appeal them.
Well, yeah,
Or-
so I think he wants a payment plan, maybe starting in 30 days.
We can
We'll
do that.
talk about how.
Just tell me how much do you think you pay every month?
40?
40, yeah.
That's just the minimum. You can pay more if you're able. And the court will issue, if you file for the reduction and the application as well as the motion, the court can consider that. And I turn those around really quickly as soon as I get them. I can go on. And I appreciate, Mr. Brown, that you do not agree with the court's verdict and findings in this case, but do you understand the terms and conditions that you're saying?
Yes.
Even though you don't agree with it?
Yes, I don't agree, but yes, I do understand it.
We discussed here in terms of the sentences going to be provided to you in writing, Mr. Brown. And Mr. Brown, you do have the right option to appeal the judgment and sentence of the court. You have 14 days from today to file a written notice of appeal. The court's going to give you some written instructions that detail how you go about filing a notice of appeal. Should you choose that option, you can discuss that further with your attorney. I think that covers everything. Anything else from counsel?
Not from the state, Your Honor.
No, Your Honor.
All right, we'd like you, Mr. Brown, you're going to
Okay,
come forward. You're
we
going to
could
collect your
shut that
copies
off and go up here and sign your paperwork.
Your Honor, may I be excused?
Yes.
Thank you.
Why don't you take that off, because I think other people are gonna be addressing the court, so